criteria as amended and approved by the Register of Trade Unions on 24 June 2010 relating to the conduct of quadrennial sectoral delegate conference of election of the teaching hospital sector of the Union. For and for such order, the Honorable Court may deem fit to make in the circumstance of this case. The affidavit is to the effect that the claimant and the defendant are members of the Senior Staff Association of Universities, Teaching Hospital, Research Institute, and associated institutions, that the defendant has a constitution, and that the defendant constituted a electoral committee for the election coming up in December 2022, and that is contrary to the provision of the Constitution. Claimant Counsel written address. The claimant counsel made submissions to support his case, and the defendant's counter affidavit is also to the effect that the constitution of electoral committee for the conference is in accordance with the provisions of the Constitution. Then the defendants also raised a point of preliminary objection that this suit is incompetent, that the defendant herein is not a juristic person, that the plaintiff has no locus to institute this suit, since the plaintiff, the person who nominated him to contest, and his branch failed to pay their check-off dues fully, that Exhibit D is made pursuant to power conferred by Exhibit B, that's the Constitution, that the genesis of this suit involves substantial issues of fact and law and cannot be determined through ordination summons, that this matter is better settled by way of complaint and not by originating summons to enable both parties to call witnesses to validate and prove their case, that the issue involved is more facts than law, that has to generate hostile proceedings that can only be resolved by calling witnesses. The principal members of the union and external bodies such as Trade Union Congress and officials of Federal Ministry of Labor who are officially involved in delegate conferences by the association would have to testify to the substantial issues of fact involved in this suit. In the written address, defendant did not address the court on the merit of the case, but rather raised 4 issues which are in the nature of preliminary objection in line with paragraph 24 of the counter affidavit. The issues are as follows: whether the defendant herein is a juristic person, whether the suit is incompetent, whether the plaintiff has a locus to institute this suit, whether the gravamen of this suit, which simplicity borders on facts and law, is not better resolved by filing a complaint and not by way of originating summons. The submissions will be referred to in the decision part of this judgment. Learned claimant counsel filed a reply on point of law on 21st March 2024. Reference shall be made to counsel submission in the judgment court's decision. The issue for determination in an originating summons are always the questions submitted for determination by the originating summons. Claimant counsel was not supposed to further formulate any other different issues for determination. Most so, in this case, there is only one question for determination which the court shall stick to. The learned Agility Esquire of counsel for the defendant did not address the court on the merits of the case, but rather raised four issues which are in the nature of preliminary objection in line with paragraph 4 of the counter affidavit. These issues shall now be considered before the merits of the case. Preliminary objection. The four questions raised by the defendant Catholic institution address, which are preliminary in nature, as follows. 1. Whether the defendant herein is a juristic person. Whether the defendant is a juristic person. Learned Counsel submitted that the defendant, the National Executive Council, Senior Staff Association of Universities, Teaching Hospitals, Research Institutes, and associated institutions is not a juristic person. It has no legal personality to sue and be sued. The National Executive Council is a mere administrative body that cannot sue or be sued. As a general rule, only natural persons, that is, human beings, and juristic or artificial, that is, bodies corporate, are competent to sue and be sued. Only natural and juristic persons in whom alone such rights and obligations can be vested are capable of being proper parties to lawsuits. The general rule requires that the plaintiff, as well as the defendant, should be juristic person or natural person existing or living in at the time of institution of the action. Huawei Himi and Nigerian Bar Association number 2 citation supplied. See also civil procedure in Nigeria by Fidelis Wadialo, second edition 2000, pages 89 and 90. Claimant Counsel response to this is that Company and Allied Matters Act 2020 are not applicable to registered trade unions. See Section 45 of Trade Union Act. By the deposition of the claimant, it is the Senior Staff Association of Universities, Teaching Hospitals, Research Institute, Associated Institutions, SSAUTHRIAI of Nigeria, that is registered as a trade union. Being a trade union and not a registered trustee, the National Executive Council, who are not said to be registered trustees, as registered trade union do not operate by registered trustees, cannot be and is not a juristic person. It cannot sue and be sued. The law is that where one of two or more claimants or defendants to a suit is a non-juristic person, the name of that party will be struck out and the suit remains valid. Where the other party is a juristic person, but where all or the only claimant or defendant is a non-juristic person, the suit is incompetent and the suit will be struck out. See Agatha Gardens Hotels and Investment Limited and others versus AG and PT Akure Ibom State citation fully supplied, where the court held, in addition, for an action to be properly constituted and competent in law so as to vest jurisdiction on a court, there must be a competent claimant and at least a competent defendant. See SDP versus INEC citation supplied. In Tukur versus Magaji and other citation fully supplied, where the court held, my lords, having held that the respondent's suit is incompetent, the proper order to make is one of striking out. CNPA PLC versus Lotus Plastics Limited and another citation supplied. Consequently, the first respondent's suit is hereby struck out for being incompetent. See also IBEDC PLC versus Landmark University citation supplied. Accordingly, there is no valid defendant in this suit. The suit is incompetent. The objection on this ground succeeds, and this suit is hereby struck out. The next question is whether the plaintiff has locus standi to institute this suit. At the end of the reasoning, I hold that the plaintiff has the locus standi to institute this suit because he is a member of the association and he had participated in the electoral process in which he was disqualified. Accordingly, he has locus standi to institute this suit. The objection on this ground fails and is dismissed. Whether the suit is competent, the submission is that the claimant has not exhausted the opportunities available to him to ventilate his grievances. I have heard that the grievances as provided by whatsoever have not been pointed out. Therefore, the internal mechanism that the claimant must exhaust and the provision making it a condition precedence for coming to court is neither disclosed in the counter affidavit nor in the written address. This submission is barren. The objection on this ground fails and is dismissed. The next issue is whether the gravamen of this suit, which simpliciter borders on facts and law, is not better resolved by filing a complaint and not by way of originating summons. I did not see any. I have read both the affidavit in support of originating summons and the counter affidavit of the defendant. There are no dispute of facts. The only dispute is as to whether the action of the defendant in setting up an electoral committee for the quadrennial sectoral delegates conference election coming up in December 2022 is allowable by the constitution of the trade union. Accordingly, this suit can be properly determined under a retained summon process. The objection on this ground fails and is dismissed. Merits of the case. In the event that the court wrongly held that the defendant is not a juristic person and thus wrongly struck out the suit, having heard the case, the court shall now consider the case on the merit. The case of the claimant apparently is straightforward and simple. It is that both parties belong to a registered trade union called Senior Staff Association of Universities, Teaching Hospitals, Research Institute, and associated institutions of Nigeria. That the union has a constitution and the constitution did not make provision for the constitution of any electoral committee for election. But the defendant went ahead and did so contrary to the spirit of the constitution, and they said illegality constituted electoral committee, and they said illegally constituted electoral committee disqualified the claimant. In submitting that the camp perusal of the affidavit and documentary evidence, especially content of Exhibit B, Union's Constitution, the plaintiff has justified why the noble court should find in his favor. Counsel did not reproduce the provisions of the said Rule 12, 13D2, and 13F2 of the Constitution of Senior Staff Association of Universities, Teaching Hospital Research Institute, and associated institutions of Nigeria, as amended and approved by the Registrar of Trade Unions on the 24th June 2010, referred to in his question for determination and relief, and to show the court how he interprets it to demonstrate how the conduct of the defendant by constituting an electoral committee for the conduct of teaching hospitals sector of quadrennial delegates conference of election coming up in December 2022 is in contravention of the union's constitution. I have looked at Rule 12, 13D2, and 13F2 of the Constitution of Senior Staff Association of Universities, Teaching Hospitals, Research Institute, and associated institutions of Nigeria attached by the claimant as Exhibit B. Rules 12A, XII, A to H confers so much powers on the national executive so as to enable it to set up an electoral committee in line with Rule 12A, XIIF, which provides that it shall be the duty of the National Executive Council, NEC, to issue directives for proper governance and administration of unions affairs. Rules 13D 2 and 13F2 of the Constitution do not talk about election nor in any way suggest that an election shall hold without an electoral committee. It is not expected that an election is to be held without being organized and officiated. So the action of the National Executive Council by considering an electoral committee was an action taken for proper governance and administration of the union's affairs, which is a duty on the National Executive Council. In his written address, Clement Council made no attempt to show or justify why the court should make an order restraining the defendant from conducting the quadrennial sectoral delegate conference election of the teaching hospital sector of the union slated for 8 December 2022 until the defendant complies with provisions of Constitution of Senior Staff Association of Universities, Teaching Hospital, Research Institute, and Associate Institutions of Nigeria as amended and approved by the Register of Trade Unions on 24 June 2010. Which provisions of the Constitution of the Union is the defendant supposed to comply with is not considered by counsel worthy of disclosure to the court, either in the affidavit or in the written address. To my mind, this is a duty of claimant through his counsel in this matter, and that duty has been abandoned. I do not consider the court to be under any duty in the circumstance to peruse the said Constitution and make any case for the claimant who has abandoned his case. The consequence is that this suit is hereby dismissed for want of merit. This is the judgment of the court and it is entered accordingly.
As the court please.
Yes, my lord. My lord, we are sincerely very grateful for the well-considered judgment. We pray the noble court be the guidance and compass of the court.
Adialeti.
My lord, very grateful for the well-considered judgment. We've learned much from the resources your lordship put into it, and we're taking consideration of this in future endeavors. We are very much grateful, my lord.
There was something I saw, but since none of you cared to address me about, I kept quiet. And that is the fact that the election is supposed to be in 2022. And here we are doing these cases in 2024, and none of you said anything about it. So I kept quiet, the way you people kept quiet.
No, my lord, I said something.
Okay.
In my reply on point of law,
yes,
I raised the issue that if the noble court has found that the electoral committee is ultra-vires, that everything that they have done, including the election and everything, should be set aside. That is our conclusion in our reply on point of law.
Oh, okay, yes, I remember that. That is the election held in 2022 should now be set aside.
Yes, my lord.
But that was raised only in your reply on points of law, which is not put. Okay, I think why I didn't consider is did not consider any part of the reliefs before the court. Okay, I remember that. That's okay. Thank you. The judgment will be ready for collection by tomorrow.
As court,
yes. Oh no. AK 31 2022. AK 31 2022. Mr. Akure Mowe Pasevio Amuluku and Ondo State Government and two others.
Yes,
appearances.
My lord, I am the claimant. Unfortunately, my counsel is having issue with his network to connect.
I
I am
can't
the,
even see you.
okay, this is me, my lord.
You are the claimant, right?
Yes, my lord.
Sure. Be able to see this thing on split screen. And because I'm the one here, I don't know what to do. Defense counsel. Defense counsel, announce your appearance.
Yes, my lord. With utmost humility to my lord. E.B. Tunde Alarakpe. E.B. Tunde Alarakpe.
That name is sounding strange.
Yes, my lord. E.B. Tunde Alarakpe. C hyphen ALARAPE, my lord.
Wait, please talk again. Let me hear your name.
E.B., my lord. E.B. Initial.
E.C.
E.B. B for bad.
E.B.
Yes, my lord. Tunde
Yes.
Alarakpe is a compound name, my lord. Tunde is spelled Tunc.
Why is it that I'm not hearing so well? Did you say what?
C-U-N, my lord. C-U.
C-U-N?
Yes, my lord. D-E. D-E.
What's the name?
Tunde.
E.B. who?
Tunde
Tunde.
Alara. Tunde is a compound name, my lord. Tunde.
Yes, Tunde
Alarakpe. A-L-A-R-A-P-E.
Okay.
Yes, my lord. I'm an assistant
What have you
director.
filed?
I appear
What
for
have
the
you
first.
filed?
My lord,
What have you filed?
we filed our statement of defense, my lord.
Were you in this matter?
No, my lord. The matter was originally for ADR, my lord. It was stated for ADR. My lord, I'm surprised the matter is even coming up for judgment today. We were never informed. No hearing notices were served on us, my lord. We're just fortunate to stumble on today's date.
No, don't tell me that. It is the pattern with lawyers. They will always fail to come. They will never know the date. But once it is for judgment, the defendant has always been failing to come, will now know the date. They will now come. It is
No,
always the pattern.
no,
So
my
that
lord.
one, you don't tell me that.
My lord, somebody just stumbled on today's date and sent us
Yes,
the
because it's for judgment. That's why you stumble on it. But if it is not for judgment, you will never stumble on the date.
My lord, this matter was originally before ADR. The claimant submitted himself and his matter to ADR. I'm surprised that he's in court at the same time.
That ADR is not before me.
When the ADR has not failed, my lord, I don't know why he went before the court when he has submitted himself to ADR. When
I
ADR
said
has,
that fact is not before the court.
as court pleases.
That fact is not before the court. So the case is for judgment.
As court pleases.
This is the judgment of the court. The claimant took out a general form of complaint against the defendants on 22nd September 2022. The defendants were served on 5th October 2022. See pages 56, 47, and 58 of the file. When the case first came up on 14th November 2022, the defendants were absent and had not filed any process. The case came up again on 22nd November 2022, and one Grace Oguntoyimbo, a legal officer in Ondo State Ministry of Justice, appeared for the defendants, and the case was adjourned for report of settlement. The case came up on 8 May 2024 for the defendants and counsel, but the defendants and counsel were absent in spite of proof of service of hearing notice at page 68 of the court's file. The defendants rather filed a motion on 8 December 2022 for extension of time to file statement of defense, and the defendants' motion of 8 December 2022 was struck out. The matter came up again on 5th June 2024 for hearing, but defendants and their counsel were absent in spite of proof of hearing notice at page 72 of the court's file, and the claimant testified, whereupon the case was adjourned for judgment since there is no process from the defendants. The claimant seeks for the following 6 reliefs. They are herein reproduced. Case of the claimant. It is the case of the claimant that he is a legal practitioner and was appointed as a special assistant to the Ondo State Governor between March 2014 to 4th August 2015 and between 30th October 2015 and 26th February 2027. His appointment letters had attached to his financial benefits that his appointment employs statutory flavor, that throughout his period of service, which people are making noise, that throughout his period of service, even though his appointment letters indicated a monthly net pay of 255,731 naira 62 kobo, he was indeed paid only 233,998 naira 3 kobo, a short payment of 21,733 naira 39 kobo for 34 months, which is 738,941 naira. But the defendants failed, refused, and neglected to pay his salaries from October 2016 to February 2017, a period of 5 months, which is 1,169,990 naira 15 kobo. That the defendants failed, refused, and neglected to pay in full the claimant's wardrobes or furniture allowance, leaving a balance of 975,585 naira 69 kobo, as well as his severance, gratuity, or benefit upon leaving office, which is 3,121,087 kobo. And so the defendant owed him a total sum of 6,179,800 naira 39 kobo. That he caused a letter of demand and notice of intention to sue to the defendant dated 24th March 2022, and the defendants replied him by a letter dated 19th August 2022, adducing inexplicable reasons for failure and refusal to pay. The claimant tendered the pleaded documents in evidence, 6 in number, which were admitted in evidence and marked as exhibit APA 1 to APA 6. Court's decision. The court shall adopt as an issue for determination whether the claimant has proven his entitlement to any of the reliefs claimed. First of all, for whatever purpose, the claimant claims that his appointment enjoys statutory flavor. To avoid wastage of verbiage, the claimant was appointed as a special assistant to the governor. By reason of Section 208 of the Constitution, the claimant was appointed to an office on the personal staff of the governor, and so his appointment was at the pleasure of the governor. See Nawa and AG Cross River State and others, citation fully supplied. The case was not defended by the defendants, and so only the claimant was heard, as the defendants did not show diligent interest in defending the suit. The claimant had two options: to ask the court to enter judgment in default of pleadings of defense as provided for under Order 35 Rule 61 of the Rules of Court, or to prove his case on the merits in the absence of the defendant. In the absence of the defendant, Order 9 Rule 51, Order 35 Rule 62, or Order 38 Rule 21 of the Rules of Court. In this case, the claimant chose the latter option. Now, there is evidence before the court only from one side. In First Bank of Nigeria PLC versus Mr. Efobi Effiong, PAM, citation supplied, the court held, it is tried law, as stated by the learned trial judge, that where evidence of a party remains unchallenged or not contradicted, minimum evidence will suffice. See also BUU versus Dada, citation supplied, Provost Lakot, that is Lagos State College of Education versus Edun, citation supplied. The minimum evidence must equally be credible evidence. In Agabi versus Ogbe, citation supplied, the Apex Court held, credible evidence in this connection means the evidence worthy of belief. And for evidence to be worthy of belief and credit, it must not only proceed from credible sense, it must be credible in the entire circumstances. The failure of the defendants to defend this suit in spite of service of originating process and service of hearing notices is also an admission of the claim. In Maje Kodunmi and others versus Ogunsheye 2017 LPLR 42547CA, the court held. It is also on record that the respondent, after entering appearance, did not file any defense, nor did he cross-examine the appellant's witnesses. In such a circumstance, the defendant will be deemed to have admitted the plaintiff's claim in the statement of claim. This is based on the principle that where a defendant disputes the plaintiff's claims or case, he must file a statement of defense and lead evidence thereon at the trial. In the case of Ben C. Emodi and others versus Mrs. Patricia C. Emodi and others, 2013, LPLR 21221, Akeju JCSA, where therefore a plaintiff files a statement of claim raising an allegation of fact against the defendants or one of them, such defendant or defendants who do or does not admit the truth of the allegation must file a defense to contradict, controvert, challenge, or deny the allegation. Where no defense is filed, the defendant is deemed to have admitted the assertion, and the court may peremptorily enter judgment against the defendant. In Answer and others versus Globacom Limited, citation supplied, the court held, a respondent who chose not to file a defense at the trial court is deemed to have admitted and at the same time accepted the claims of the appellants. And Section 75 of the Evidence Act provides that facts admitted need no further proof. See also Okebo and Police Council, citation supplied, Visafon and Onamusi, citation supplied, and MTC Pioneer and others versus Adeye, citation supplied. As to the claim of the claimant, I find as a fact that the Office of the Special Assistant to the Governor is included in the table titled Financial Implication of Remuneration for Executive, Legislative, and Judicial Office Holders at the state and local government levels, Exhibit APA3. I also find as a fact that the claimant wrote a letter of demand to the defendants, Exhibit APA5. The demand is for the sum of 5.2 million naira, broken down as follows. A, Unpaid salaries for 5 months, 1,169,990 naira 15 kobo. Furniture allowance balance 975,585 naira 69 kobo. Severance gratuity 3,121,875 naira 75 naira. The Ministry of Justice also replied by a letter of 19 August 2022, Exhibit APS6, attaching the response of the Permanent Secretary to the claimant's demand. The said response is worth reproducing hereunder as follows. I now read the letter. Letter of demand for payment of unpaid 5 months salaries and other entitlements of Amuluku A. Pasevio. I wish to refer to your letter of 2nd June 2022 on the subject above and to confirm that Mr. Amuluku Akikoromowe Pasevio actually served during the previous administration as Special Assistant SA to Governor Mimiko between March 2014 and August 2015. He was also appointed as SA between October 2015 and February 2017. It is of note that payment of the various entitlements is not peculiar to Mr. Amuluku. It is of note that non-payment of the various entitlements is not peculiar to Mr. Amuluku, as government is yet to decide on how to settle all affected political office holders who served during the period due to paucity of funds. 3. However, you may wish to know that Mr. Amuluku may not be entitled to the sum of 975,585.69 kobo as claimed on furniture allowance in his petition, in view of the fact that towards the end of the previous administration, when he served as special assistant, government decided to prorate the furniture allowance of all political office holders due to paucity of funds. Mr. Amuluku, as well as others, collected the prorated fund without any complaint, an indication that they agreed on the amount paid. Consequently, the Ministry of Justice may wish to inform the petitioner that government is not in the position to pay such allowances now as a result of paucity of funds, and whenever government decides to pay others, Mr. Amuluku would also be considered. Thank you. F.O. Oladiron, Permanent Secretary. That's the end of the letter. From the content of the response of the Permanent Secretary, the defendants admit all the claim of the claimant except the sum of 975,585 naira 69 kobo being claimed for balance of furniture allowance on the ground that the claimant and others were paid the balance prorated. The claimant who produced this document in evidence did not plead any facts contrary to this assertion. The sum admitted is therefore 5,267,000 naira 450 naira 4 kobo minus 975,585.69 kobo, which is 4,291,865 naira 15 kobo. The claim for a short payment of 21,133,039 naira 39 naira for 34 months, which is now 738,941 naira, was not included in the letter of demand, and there is no evidence of any complaint while in office seeking for any clarification. This head of claim is refused. Accordingly, and for the avoidance of that, the case of the claimant succeeds in part, and it is hereby ordered as follows. A. The defendants are hereby ordered to pay the claimant the sum of 4,291,865 naira 15 kobo as follows. 1. Unpaid salaries for 5 months is 1,169,990 naira 15 kobo. Severance gratuity is 3,121,000 875 naira. The judgment sum is to be paid within 30 days of this judgment, or the sum shall attract 10% interest per annum. This is the judgment of the court, and it is entered accordingly. Yes, Tunde Alarakwe.
Yes, my lord.
You are
My
from
lord.
the Ministry of Justice?
Yes, my lord.
You didn't tell us your rank.
I said it, my lord. Assistant Director.
Okay,
Ministry of
Assistant
Justice.
Director.
Yes, my lord.
MOJ.
Yes, my lord. We commend my lord for the well-researched
Conducted.
judgment. Yes, my lord.
Tunde
Alarape.
We commend my lord.
Your lordship for the well-researched judgment and for the industry put into the judgment, my lord. We are most obliged, sir.
Thank you.
But my lord, may I be permitted to say this, sir? My lord,
Yes.
we filed a statement of defense
It was
dated.
struck out.
Oh,
If you were listening to me very well, it was struck out. You
as
came
copies.
with by emotion, isn't it?
Yes, my lord.
Yes, it was struck out.
As God pleases.
When we saw that you were served for the hearing of that day and nobody came, so it was struck out. That was what paved way for him to be heard alone at the next adjourned date.
As the God pleases. We are most obliged, sir. Yes, my
All
lord.
right. A
Yes,
copy of the judgment will be ready for collection by tomorrow.
As God pleases.
NICN IL 12-2023. Appearances. Dr. Anthony Olayemi Ajiboye and Federal Civil Service Commission. If you are in the matter, announce appearance now. Announce your appearance. Okay, Claimant Counsel, is the Claimant Counsel online? Yes, you are. Eh? Who? You just calm down. I'm not hearing you. You are too fast. Okay. Anya Kuhu? Anya Kuhu? Yes, you too, like the other persons will just finish their defense, their judgment. When the matter is set down for judgment, you will suddenly be aware. But when it is not set down for judgment, you are never aware. But you as counsel, you know that the court has no business with that one, isn't it? You know that it does not stop court from proceeding. Anyway, what have you filed? The most important process is the motion on notice. You are not saying that. Yes. All these points that you say you file is a motion you file in order to bring them in. We have a motion for extension of time to file our memorandum of appearance, statement of defense, etc. Yes, so what do you want? Has it been served? You see, because it's for judgment today, you are able to file in Ilorin. In fact, you filed in Abuja on the 28th, and it was able to reach here what date? Yesterday, because you know the matter is coming up for judgment. If not, what do they used to do, Chola? The team will be there where they have filed it. They will just come to court and say, but we filed, we have our copy. But because they know that today is for judgment now, they are able to send it. You was able to reach court. Anyway, so what do you want? Yes. Yes. What do you want? The claimant is not in court. You have not. Huh? What? Claimant. Dr. Anthony Olayemi Ajiboye. Nobody. Neither his counsel, Iyanda. IK Iyanda. They're not online. Yes. You have any proof of service on the claimant? See, I didn't go to grammar school. Do you have any proof of service on the claimant? Where is it? So you don't have. It's a simple question and answer. Do you have proof of service? So what do you want now? Do we have any date to come back within this July? Which date?
Hello, my lord.
Hello, sir. Hello, sir. We were muted.
Who muted you?
The host.
Okay, maybe you were making noise. Yes, who are you?
No,
who are you?
Not making, we Dr. Ajiboye Olayemi and Tony, sir. My lawyer beside me too, sir.
Eh?
My lawyer is also beside me. We are together, sir.
You are the one leading your lawyer?
No, my lord, I'm here too.
So why did you allow your client to be the one addressing the court on your behalf?
No, my Lord, we are using two devices. So I think I was muted.
Okay, what's your name?
My Lord, I.K. Inyada for the claimant.
Yes, one Ayaku Abubakar has appeared for the defendant. And I have before me a motion for extension of time to file memorandum of appearance and statement of defense. Have you been served with that motion?
My Lord, I have not been served.
So what do you want?
My Lord, sir, the business of the day is for the noble court to deliver its judgment.
Yes.
So any motion is just an attempt to arrest the judgment of the noble court.
Okay.
They have been served since October 3rd, 2023.
Yes.
Several hearing notices.
You are still making grammar, laying foundation. First, start with telling us what you want before you give us all those reasons.
My Lord, I urge the noble court to proceed to deliver its judgment.
I hope you are hearing him. I just said I hope you are hearing him. Yes. You didn't hear him. He said today the business of the court is delivery of judgment. And since you have been served, since when I should proceed to deliver judgment? You are explaining service.
You see, but when the issues, what is to break life and what is to just what should be taught, not let's say even with the night. Because of that life and things are treated in that where to give the life to the man like this. Because of the extension of time to give life, they will let the process. They know that the use of the God of which because that is very much to prevent them. Which is done and not let's say that's let's say land go to
It is in the interest of justice to first hear the defendant's motion on notice, and since it has not yet been served, this case ought to be adjourned for the said motion. Case adjourned to 22nd July 2024 for hearing of the defendant's motion or notice.
Hello, sir.
Yes.
I want to plead with the noble court that if you can have by Zoom, sir.
Okay.
22nd is a Monday.
The hearing of the motion shall be by Zoom.
Ask copies. My Lord, we are sincerely very grateful.
Yes. Thank you.
Grateful, my Lord.
All right. Any other matter? Well, that is all for the day, and we shall all leave.
Ask copies. Authority, and kind of Kalomutiwa.
Oh, still mute everybody.
No, I want the Kalumuti.
Already you want to consider.